Brown, again, Justice Kennedy, a Reagan justice, switched sides. And as the Wall Street Journal points out, Justice Alito, who wrote the main dissent, rocked back and forth in his chair as Justice Breyer spoke. He was very upset about this, frowning in apparent disagreement. For the second time in a week, Justice Alito summarized his dissent from the bench, a signal of his intense disagreement with the majority. Speaking for about 10 minutes, Justice Alito said the majority had thrown aside standard legal procedures to strike down the Texas law, ignoring rules that should have precluded the court from considering the appeal altogether. Now, what was the deal with it? Well, interestingly enough, we see all this stuff out of Brexit. People saying, we need a do-over. I'm not happy with the results. I want to hold another election. I don't like that. Okay? That's essentially what this was. This, in principle, this whole Supreme Court decision was essentially a do-over for these people. And that's what he was pointing out. It was also ignoring the law, also ignoring legal principles, and it was pure activism. This is not a review of the law. This is not a review of the Constitution. This is nothing less than naked judicial activism. And that's why Justice Alito was rocking back and forth in his seat. He could barely contain himself. He could hardly sit there and listen to this nonsense. And then he wrote this opinion. And I pulled up his opinion, and I want to read you part of it because these opinions are very long. This is like 150 pages of stuff to sort through. This is what he has to say at the beginning of his opinion. He says, the constitutionality of laws regulating abortion is one of the most controversial issues in American law. But in this case does not require us to delve into that contentious dispute. You understand? He said, okay, regardless of what you think about the issue, there are legal principles here that would keep us from being involved in this. He said, instead, the issue here concerns a workaday question that can arise in any case, no matter the subject, namely, whether the present case is barred by res judica, okay? And so what he talks about with that is he's essentially saying, hey, look, to put that in layman's terms, okay, because I'm not a lawyer, but he explains it in his opinion. He says it's basically claim preclusion. It's a bedrock principle, he writes later on in his decision. He says, if you lose on an issue, you don't get a do-over. You don't get a do-over, just like you don't get a do-over with Brexit. And he goes on to say here, he said, here's the worst example. Shortly after Texas enacted this bill, the petitioners in this case brought suit claiming, among other things, that a provision of the new law requiring a physician performing an abortion to have admitting privileges at a nearby hospital is facially unconstitutional and thus totally unenforceable. Petitioners had a fair opportunity to make their case, but they lost on the merits in the Court of Appeals for the Fifth Circuit, and they chose not to petition the Supreme Court at that time. So the judgment became final. So they lost. They lost. But then they come back a few years later and say, we want to do over on that, like Brexit. Okay? So this is precisely what is happening with this. And he goes, you don't get to do that. This is exactly this case. This isn't a similar case. This is exactly that case. You lost. You didn't appeal. You don't get to come back now and do this. Okay? Under the rules that apply in regular cases, he says, petitioners could not relitigate the exact same claim in a second suit. The exact same claim. As we have said, a losing litigant, and he quotes the Supreme Court, and he gives you book, chapter, and verse, okay? Quote, a losing litigant deserves no rematch after a defeat fairly suffered in adversarial proceedings on an issue identical in substance to the one he subsequently seeks to raise. You get that? Okay. In other words, no do-overs, folks. Now, he says, however, because this is an abortion case, we throw out the law, we throw out the rules, we throw out all of our previous opinions. He said, this rule is now disregarded, and the court awards a victory to petitioners on the very exact claim they unsuccessfully pressed in the earlier case. Now, when we come back, there's more. There's more that is ignored on this, and I want to read to you what the Supreme Court decision says, why they said they did this. It's absolutely amazing, and I think it underscores why we cannot trust 9 political appointees to safeguard the Constitution. Welcome back to the Alex Jones Show. I'm David Knight on this Monday, and we're looking at June 27th. We're looking at the Supreme Court case, and I wanted to give you an example of just how corrupt this whole system is. I mean, we've got people in Brexit saying we need a do-over. I don't like the results. We got the Supreme Court actually giving a do-over, which is against their previous rulings. It's against the law to do this. These people already lost. They didn't appeal the case, but now they gave them a do-over and said, all right, and now we're going to reverse what happened earlier. And then, of course, in politics, we see over this weekend an orchestrated attempt by the never-Trumper GOP, I'm with her Hillary people, okay, people like George Will, National Review, David French, the guy that was a candidate for about a week. You got this guy who's filed suit in North Carolina, in Virginia. They want a do-over as well. They want to say, hey, we are delegates and we have superior First Amendment rights to you people. What our opinion is, it matters more than millions of voters in these elections. And so we're going to say that you can't penalize me. We're going to sue you over this. So over and over again, we're seeing people say we want a do-over. The abortion law, Brexit, the GOP convention. Everybody is saying, hey, I didn't win, and so I'm going to change all the rules right now. I'm going to say all the rules don't apply, and I'm going to do whatever I have to. I'm going to suspend your free speech because I don't want to debate science with you when it's climate change. I don't want to hear what you have to say, so I'm going to call you a hateful racist and shut you down with hate speech laws. I'm going to do whatever I can to silence, to censor you, to pervert the law, the rule of law, the rules of democracy, the rules of our republic, just so I can get my way. This is what we're seeing increasingly. So I want to break this down because, as I pointed out before, Justice Alito could barely contain his anger. He was rocking back and forth in his seat, and I would have been too if I had been there. I would have been going back and forth. I was like, I can't believe this is happening. This is just, we're throwing everything out. And we've seen the Supreme Court do this before. We saw them do it on gay marriage. Regardless of what you think about gay marriage, they have no jurisdiction. Where is it in the Supreme Court that says the federal government will have jurisdiction over defining marriage? There is nothing in the Constitution that delegates that to them. We had people who were very concerned who did not want to have a federal government, the anti-federalists, they called them. They said, we don't want to have this. We know that this is going to turn into a monster that is going to dictate the most minute details of our lives, assuming and concentrating power to itself. And that's what's happened. And so they passed the Bill of Rights. And they said, this is off limits, that's off limits, that's off limits, that's off limits. And then they said, oh, and by the way, in case we forgot anything, we're going to write a 9th and a 10th Amendment. And we're going to say, if we didn't specifically give this power to you specifically, then you don't have it. Anything that's not been delegated to you remains the power of the people and of the state governments. That's the 9th and 10th Amendment, essentially. They just ignore that. And if they like the cause, the Supreme Court has shown that it will just set aside all the legal process. And this is why Judge Alito was so upset about this. And we had other people on. We had Lionel when we were talking about the gay marriage thing. He thought it was a good deal. I don't like that definition of marriage. But we both agreed that they don't have any legal authority to define it. So, I mean, it's something that ought to be decided at the state levels, at the community levels. Before I get back to that, real quickly, we have a couple of sales that are ending soon. I want to let you know about these. That's the 20% off for Deep Cleanse. And, of course, when we put our best seller on a deep discount like this, it isn't going to last long. And so that sale is not going to last long. This is our Rolls-Royce, our all-in-one cleansing product. Instead of buying 5, 6, or 7 different cleansing products, we've used decades of scientific research to put together Deep Cleanse. And again, it is our best-selling product. We've put it on a deep discount, 20% off at InfoWarsLife.com. That's not going to last much longer. Also, the Hillary for Prison T-shirts. That is going to be ending soon as well. If you get the Hillary for Prison T-shirts, you can get 75% off the Hillary for Prison T-shirts if you sign up for the InfoWars newsletter at InfoWars.com/newsletter. We're going to be forced to pull this special very soon because they are going very quickly, you can imagine, at that kind of a discount. It's a huge discount off of T-shirts that are already very competitively priced for T-shirts. It is a great design, and to say the least, it will be a conversation starter because as we've seen many times, many people look at it as such a dead ringer knockoff of the Hillary for President appearance, but it's Hillary for Prison, and so that gets a conversation started. Let's talk about what's going on with the Supreme Court situation. When we come back, we're going to take a look at this move to shut down the Trump nomination. Can you believe that they're still trying to do this? It's absolutely unbelievable. And then we're going to look at the whiny millennials who say, those baby boomers, they are ruining our future. And you've seen the memes on social media where they show the inversion that the vast majority of people who are younger voted to stay in and vice versa at the older ages. We'll be right back. Welcome back to the Alex Jones Show. I'm David Knight, and we're talking about the do-over mentality that we've got here. The spoiled brats everywhere, from Britain to the Supreme Court to the Republican Party. I didn't get my way. I want it done over again. I don't care what the rules are. I want it my way. That's exactly what they're saying. And that's what Justice Alito was pointing out the Supreme Court just did. And so to summarize what I was saying earlier, what he did was he said, look, they already appealed this. They lost at a circuit court level. They did not appeal it to the Supreme Court, so that decision was final. Now they have come back with exactly the same case, exactly the same law, and tried to appeal it again. They've already lost. We don't allow that. The Supreme Court has said that's not allowed. It's a legal principle. That's not allowed. And then he goes on to say, and here's another principle that they have here. He says, it doesn't even matter. He says, I understand abortion is a very contentious and divisive issue. This doesn't even get to that. It's a question of legal procedure. If you lose a case and you don't appeal it, you don't get a chance at a later date to relitigate. A do-over. Okay? That's what he said. And then he goes, you've got another standard rule of law that is ignored as well. He said, it's a severability clause. The court's treatment of this Texas law's severability clause. He says, when part of a statute is held to be unconstitutional, the question arises whether other parts of the statute must also go. If a statute says the provisions found that are unconstitutional can be severed from the rest of the statute, the valid provisions are allowed to stand. You understand? So they come in here and they say, well, we don't like this rule about the fact that you have to be admitted to a hospital. We think that's too much of a burden. Okay, fine. Then the other parts that say you've got to meet fire code inspections if you're going to do medical procedures in this little house that you just bought and you've now put a shingle out, said, this is a health clinic for women. Okay, fine. Let's make sure they don't burn up while they're being treated there. Or let's make sure that you can get gurneys inside here if somebody has to get pulled out quickly with an ambulance. Issues like that, safety issues. And he says, for example, he says if provisions can be found unconstitutional, can be severed from the rest of the statute, the valid provisions are allowed to stand. This law contains what surely must be the most emphatic severability clause that was ever written. In other words, they say in this law, we've got all these different things here, and each one of them is severable. These are all separate regulations. It isn't all together, all or nothing. Each one of these things are separate. And he says this is very explicit. He said the clause says every single word of the statute and every possible application of its provisions are severable. He says provisions that are indisputably constitutional, for example, provisions that require facilities performing abortions to follow basic fire safety measures are stricken now from the book, okay, based on the Supreme Court decision. So they took all of the regulations out. He says there's absolutely no possible justification for this collateral damage. Now, let me read you the nonsense that was put out here by these 5 Supreme Court justices. This is the basis for their decision. The number of facilities providing abortions dropped in half, and this is actually a Supreme Court decision. This is not a New York Times analysis of what's going on. This is what the Supreme Court justices said was the basis for their ruling. The number of facilities providing abortions dropped in half from about 40 to about 20. This decrease in geographical distribution means that the number of women of reproductive age living more than 50 miles from the clinic has doubled. The number living more than 100 miles away has increased by 150%. The number living more than 150 miles away by more than 350%. The number living more than 200 miles away by more than 2,800%. You see the issue here? This is an issue of whether or not they want people to have abortions. It doesn't even address the legal issues that Judge Alito was so upset about. They just said, well, we like abortions. We want them to be plentiful and easily accessible. And so we don't like this, and we're going to strike all of the rules, including fire safety codes, because, this is about women's health. This is about women's health, isn't it? What a baloney. Here are these people who have absolutely no health regulations in abortion clinics. They struck them all. Yet they want to regulate